There are 3 related offences under the umbrella of criminal damage. These are all contained in the Criminal Damage Act 1971. 1. Simple criminal damage under Section 1, 1. 2. Aggravated criminal damage under Section 1, 2. And 3. Arson under Section 1, 3. This video will focus on aggravated criminal damage under Section 1, 2. Section 1, 2 of the Criminal Damage Act 1971 provides, a person who destroys or damages any property, whether belonging to himself or another, intending to destroy or damage any property or being reckless as to whether any property would be destroyed or damaged, and b. intending by the destruction or damage to endanger the life of another or being reckless as to whether the life of another would be thereby endangered, shall be guilty of an offense. Essential differences from simple criminal damage under Section 1, 1. 1. The property need not belong to another. 2. The defense of lawful excuse under Section 5, 2, does not apply. 3. The mens rea in relation to endangerment of life. 4. The punishment is maximum life. The actus reus of aggravated criminal damage consists of 1. Destroying or damaging. 2. Property. Destroy or damage has the same meaning as for simple criminal damage, but there must be a causal connection between the destroying or damaging of the property and the endangering of life. This means the danger to life must come directly from the damage to the property. In R.V. Steer, 1987, the defendant had had an argument with a former business partner. He went around to his house in the early hours of the morning armed with a gun. He rang the doorbell to awaken the occupants and then fired 3 shots damaging the windows and door. His conviction under Section 1, 2, was quashed as the danger to life came from the gun and not the damage to the property. The prosecution does not have to show that life was in fact endangered by the damage, nor that the damage in fact done created any risk to life, so long as the defendant, by damaging the property, intended or was reckless as to the endangering of life. In R.V. Sanger, 1988, the defendant had been drinking all day and set fire to a mattress and 2 chairs in his neighbor's flat. The flat was unoccupied at the time. The block of flats was of a particular design which meant that people in neighboring properties were not endangered. His conviction was upheld. There was no requirement that life should in fact be endangered under Section 1, 2. The test to be applied was whether an ordinary prudent bystander would, at the time when the fire was started, have perceived an obvious risk that property would be damaged and that life would thereby be endangered. The fact that there may have been special features which prevented the risk from materializing was irrelevant. Section 10, 1 of the Criminal Damage Act 1971 defines property as property of a tangible nature, whether real or personal, including money and including wild creatures which have been tamed or are ordinarily kept in captivity. b. Not including mushrooms growing wild on any land or flowers, fruit or foliage of a plant growing wild on any land. The mens rea is either intention or recklessness as to destroying or damaging property belonging to another. In addition, the mens rea of intention to endanger life or recklessness as to whether this occurs needs to be established. The defendant must be proved to have intended the damage or destruction of property. In R.V. Pembleton, 1874, the defendant threw a stone at some men to disperse them. It missed and hit a window. He lacked the mens rea as his intention was to scare the men, not to destroy or damage property. 2. Recklessness. RVG and R. 2003 set the meaning of recklessness in relation to criminal damage, overruling Caldwell recklessness on this point. A person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971 with respect to I. A circumstance when he is aware of a risk that it exists or will exist. e. A result when he is aware of a risk that it will occur, and it is, in the circumstances known to him, unreasonable to take the risk. In summary, Aggravated criminal damage is an offence under Section 1, 2 of the Criminal Damage Act 1971. It is where the defendant intentionally or recklessly destroys or damages property and intending by the destruction or damage to endanger the life of another or being reckless as to whether the life of another would be thereby endangered. If the damage or destruction is caused by fire, it would also be arson under Section 1, 3. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.